United Kingdom spouse or partner visa application process. Partner or spouse of British citizens or people who are settled in the UK can apply for a visa to join or remain with them in the UK. The key features of a spouse visa are as follows. 1. If you don't live in the UK, you will apply for leave to enter. 2. If you are in the UK, you will apply for leave to remain. 3. If you have had a partner visa for 5, or in some cases, 10 years may be eligible to apply for indefinite leave to remain. How to make an application. The correct application form must be used in its most recently published version. The correct application fee has to be paid and an original valid form of identity document submitted. Applications also require payment of the NHS surcharge. There is no NHS fee if you are applying for indefinite leave to remain. A successful application will generally result in a grant of leave to enter the United Kingdom for 33 months or leave to remain for 30 months. During that time, the person is allowed to work but cannot access public funds unless they request an exception due to poverty. The applicant can apply for indefinite leave to remain after 5 years. The exception is where an application is granted leave based on exceptional circumstances, in which case the applicant would need to wait 10 years before applying for indefinite leave to remain. Generally, there are 2 main requirements to be met to qualify for a spouse visa. The requirements are suitability and eligibility requirements. Suitability requirement. A suitability requirement evaluates the applicant's character to assess if there are reasons why they should not be admitted to or allowed to remain in the UK. There are mandatory and discretionary grounds to refuse applications for suitability reasons. Mandatory grounds mean that Home Office officials must reject the visa application for this reason. Discretionary grounds means that the Home Office may reject the application but may choose not to. In some instances, it is very likely that they will, in others less so. Under mandatory grounds for refusal, the main reasons why an application will be refused relates to criminality. For example, a person who is the subject of a deportation order, or having been convicted of an offense and sentenced to a period of imprisonment of at least 4 years. In the case of sentences between 1 and 4 years, the application will be refused unless a period of 10 years has passed from the end of the sentence. For sentences of less than 12 months, the person will need to wait for 5 years before applying. Even in the absence of any conviction, some circumstances will lead to a refusal if the Home Office is satisfied that the exclusion of the applicant is conducive to the public good. Public good grounds of refusal was introduced with suspected terrorists in mind. But the wording is broad and potentially catches a variety of situations. For example, the Home Office can refuse an application simply because the applicant has a pending prosecution, or has not paid taxes to Her Majesty Revenue and Customs. Other mandatory grounds not linked to criminal offences are the refusal to attend an interview if asked or failure to provide information and medical reports. Finally, an application will be refused if it is considered that the applicant's parent or partner poses a risk to the applicant. For example, in the case of convictions against a child of sexual offences. Discretionary grounds for refusal. Some of the reasons have to do with the application itself. Failure to disclose material information or the production of false documents will generally lead to a refusal even if the applicant was not aware of the deception. If the Home Office considers it conducive to the public good, the application can also be refused in cases of criminal offences where the following applies. 1. There was no prison sentence. 2. There was an out-of-court settlement. 3. The Home Office thinks that the offense caused serious harm, or 4. The person is a persistent offender who shows a particular disregard for the law. Eligibility requirements. The eligibility requirements relate to the relationship between the applicant and the sponsor, maintenance and accommodation needs, and knowledge of the English language. Applicants from certain countries must also undertake a tuberculosis screening. Maintenance and accommodation requirements. The maintenance requirement consists of mainly the financial earnings of the sponsor and the size and space available in the accommodation where the applicant will live with the sponsor. Relationship requirements. The sponsor must be a British citizen or settled in the UK, or have limited refugee or humanitarian protection leave. Both the applicant and the sponsor must be 18 or over at the date of the application and must not be within the prohibited degree of relationship. They cannot be closely related to each other in such a way that it would be against the UK law to marry. Additional requirements are that the parties must have met in person and have a genuine and subsisting relationship, and intend to live together permanently in the UK. If the parties are married or in a civil partnership, their marriage or partnership must be valid, and any previous relationship must have broken down permanently. Fiancés must be seeking entry to marry. In extension and indefinite leave applications, the relationship requirements are the same, but the applicant must also provide evidence that since entry clearance or leave to remain as a partner was granted, they have lived together in the UK with the sponsor. If there is a period in which they have not lived together, they should give a good reason for it, consistent with a continuing intention to live together permanently in the UK. This means that long absences must be explained, and it has to be shown that the couple still intends to maintain their family home in the UK. Applicants who wish to extend their leave must also satisfy the immigration status requirements. This means that the applicant must not be in the UK as a visitor or with leave granted for 6 months or less, unless it was fiancé leave, and they must not be on immigration bail. English language requirements. Knowledge of the English language must be demonstrated in applications for leave to enter or remain. One way to do this is to provide evidence that the applicant is a citizen of a majority English-speaking country. In entry clearance cases, applicants from other countries must have passed an English language test in speaking and listening at level A1 or above of the Common European Framework of Reference for Languages. The test is valid only if it was taken with a provider approved by the Home Office. Level A1 is the minimum level required, so nothing stops an applicant from taking a higher test. Applicants who have an academic qualification at bachelor's degree level or above are exempted from taking the test if the certificate was awarded in the UK, or if it was taught or researched in English and is deemed acceptable by an organisation called UK NARIC. The only people exempt from the English language requirements are those over 65, those with a disability, or in cases of exceptional circumstances. For extension of leave applications, applicants must prove that their English has improved, by providing a certificate at level A2. Indefinite leave applications require level B1 in speaking and listening, and the Life in the UK test. Evidence of knowledge of English must be submitted in the form of original certificates. Applications for indefinite leave to remain. It is possible to apply for settlement upon completion of 60 months of leave accrued under Appendix FM. Applicants relying on exceptional circumstances, not covered in this post, will need to wait for 120 months. Below are a few additional points to note. 1. Any leave granted as a fiancé or proposed civil partner would not count. 2. It is not possible to mix and match partners. Any leave granted on the basis of a previous partner cannot be added to the current leave for the purpose of accruing the relevant 5 or 10-year period. 3. It is essential to ensure that there are no excessive absences to prove the intention to permanently live in the UK. Bereaved partners and victims of domestic violence. An applicant can apply for ILR even if they have not yet completed their 5 or 10 years residence in the UK in the following circumstances. 1. If the sponsor dies while the applicant has not yet completed the relevant 5 or 10-year period. Bereaved partners will be granted indefinite leave to remain unless insufficient time has elapsed since the applicant was sentenced to up to 4 years imprisonment, in which case limited leave to remain will be granted, and the applicant will be able to apply for indefinite leave to remain in due course. 2. Victims of domestic violence can also apply for indefinite leave to remain if their relationship breaks down before the end of the relevant period. The applicant must provide evidence that during the last period of limited leave as a partner of a British citizen or a person settled in the UK, the applicant's relationship with their partner broke down permanently as a result of domestic violence. Thank you for watching the video. For more information, please call +44 0203 0927 762. Please don't forget to like the video and subscribe to our channel so that you can receive notification when we upload new videos.